So welcome to this webinar dedicated today to the labor mobility and the CETA trade agreements. We are very happy to host it today. As you know, the European Union Chamber of Commerce in Canada promotes and supports the trade and business relations between the EU and Canada, and also the CETA implementation. Just before giving the floor to Adrian Thomas, the EU-CAN president, I would like to give just a few details regarding the webinar. So we will have first the presentation made by our guest speaker today, Natacha Mignon, and then we'll have a Q&A period when you will be able to ask some questions. For that, we would like to ask you, if it's possible, please to use the Q&A button on the screen and to ask your questions. And maybe one more detail, just regarding the questions, and because of the scope of the webinar today, we would like to kindly ask you and recommend to keep your question within the scope of the CETA trade agreement and the labor mobility provisions. Thank you again to everyone, and I'm very pleased to give the floor to Adrian Thomas, the EU-CAN president.
Great. Well, welcome to everyone who's joined us here. This is the second time we've discussed this topic, and it's great to see so many people join us. It's our second session of our what we call our Access to Market webinar series. And the goal is for these series to help both EU and Canadian companies and professionals understand how they can benefit from the labor mobility provisions under CETA, which is a comprehensive economic trade agreement. So good morning, I'm Adrian Thomas. I am the president of the European Chamber of Commerce in Canada, which we call EU-CAN. Happy to be here to kick this off. EU-CAN, for those who are not familiar, we are the business voice of European businesses in Canada. We work with our members to advocate, to inform, and to represent them on key topics. I can say labor mobility is a common theme across all sectors and all of our members and all the companies that I've spoken with. And so I'm sure this is going to be a great and informative event. For just some brief background on the topic of today and CETA and labor mobility, many of you in business have probably recognized the low unemployment rates and the challenges we have around labor shortages. It continues to impact employers in Canada. Over the past few months, to address this, we've seen the Canadian government issue an increasing number of work permits, over 640,000 work permits between January and October of 2022 alone. Through the partnership between the European Union and Canada and the CETA trade agreement, can the EU share preferential trading relationships, as well as mutual objective to facilitate trade and services, and to deepen our business relationships. CETA, and specifically in the chapters 10 and 11, can help us fill Canada's workplace shortages by offering a number of alternatives to facilitate labor mobility, skills transfers, and to support EU and Canada business for certain covered business people. So the expert with us today, I'm pleased to introduce our guest speaker, Ms. Natacha Mignon. She is a lawyer and partner at Immetis, an expert on international mobility, business immigration in Canada, and has written numerous articles related to this topic. And we were also fortunate to have her last year also to speak on this topic. So once again, thanks all of the participants for joining us. And thank you very much, Natacha, for hosting this. And with that, the floor is yours.
Thank you very much, Adrian, for your presentation. Thank you, Mary. Can I share my screen?
Yes, please.
Okay, thank you very much. Okay, can you just confirm that you're seeing my screen?
Yes, it's fine, Natacha. Thank you very much. We can see the presentation.
Okay, thank you very much. I'm really pleased to be here to discuss about CETA's labor mobility provision. Thank you for having me. Thank you to the EU-CAN for all the great work that you do continuously to promote CETA. So my name is Natacha Mignon, partner at Immetis Legal Services, as Adrienne mentioned, and we're a law firm specializing in immigration in Canada. So we help companies hiring foreign people in Canada or EU companies transferring their skilled workers in Canada. And we've been one of the first immigration law firm in Canada using the CETA provision relating to the labor mobility. Before going more into details and into the details of CETA, I'd like to give you a brief overview of the labor market in Canada. You currently have over 5,000 job vacancies across Canada. You have almost 40% of the Canadian companies which are expecting to face obstacles when hiring skilled people. So in that context, you really have to understand that immigration is the key to Canada's economic growth. And currently, as Adrienne mentioned, we have over 400,000 people holding a work permit in Canada. Now, it is believed that 23% of the Canadian population are immigrants. So in this context, you really have to understand that immigration in Canada is a huge machine. And I'd like during this presentation to help you understand its basic rules. When, and I'm going to concentrate, of course, on EU citizens. So as a EU citizen, you don't need a visa to enter Canada. What you need is to file an ETA, so it's an online filing, you pay $7, it's called an ETA, Electronic Travel Authorization. And that will allow you to stay up to 6 months in Canada. But that will give you a visitor status. So from the moment you have another project, whether you want to work, study, operate a business, or stay in Canada, then you'll have to apply for a specific status. And we'll concentrate here today on the work permit, on the working status. And it's important to also understand that whatever the sector of activity you're working in or the circumstances, there are very few exceptions to that rule of obtaining a work permit to come work in Canada. So even if you're an EU company, you have a Canadian subsidiary in Canada, and you're facing a high volume of activity, if you want to transfer people from the mother company in Europe to Canada, they will have to have a work permit. And this is where we're going to get some help from CETA. So the basic rules to obtain a work permit is for the employer to prove that he has not been able to hire Canadians or permanent residents. The process is called a labor market impact assessment. But, so this is quite complicated process, but there are exemptions and exceptions to this process. And where we're going to talk of CETA Chapter 10 is that CETA Chapter 10 provides a new list of exemptions allowing EU citizens to obtain a work permit more easily. So let's see this EU-Canada mobility of professionals under CETA. Before we discuss each of the possible work permits under CETA, I'd like to point out the advantages CETA has brought regarding the entry of workers. So, firstly, CETA has eased the mobility of professionals between the EU and Canada, bringing new specific work permits, so giving access to specific work permits to EU citizens. Also, it facilitates the temporary transfer of EU executives in Canadian branches, Canadian subsidiaries. Another very interesting advantage is that it gives the opportunity to skilled workers, to EU skilled workers, to come to Canada on a temporary mission as contractual services suppliers. So they don't need to be hired by a Canadian company. They can just come perform a work as a consultant. So this is really helpful. And lastly, the status of business visitor has been implemented and facilitated for EU citizens. So the list of specific LMIA exemptions under CETA is the following. So you have the intra-corporate transferees, the investors, the contractual service suppliers and independent professionals, and the business visitors. I'd like to start with the investors. This is a brand new work permit available to European citizens. This already existed, this permit, the specific permit already existed for Americans and Mexicans under the NAFTA agreement, now called USMCA. So it's kind of a work permit that is copied on that other agreement. What's interesting there is the fact that you're a European company investing in a Canadian company. You now have, with this new work permit, the possibility to send a key person to Canada to establish, develop, administer the investment made by your company. And this person will be able to obtain a work permit for a period up to a year, which can be renewable. And it's a new vehicle because previously, before we had this new work permit, it was not that easy in those circumstances to have people obtain a work permit. Of course, we could always try to use the intra-company transfer, but here you can send someone who was not working with your company initially, because when using the intra-company transfer, you need to, the person you can transfer must have been working with your company for at least 12 months. Here, you're making an investment through your company in a Canadian company. The Canadian company does not need to have any relation with your company in Europe. And this person who's never been working with your company in Europe can get a work permit to work on this, to work on this investment made by the European company. So that's an interesting new work permit. Now the contractual service suppliers and independent professional work permit. We've been using this category a lot, and actually I don't remember how we used to do when it didn't exist. Here the situation is the following. You have two companies, one in the EU and one in Canada. The two companies do not have any relationship. The only thing they have is a signed contract. So you have an EU company signing a contract with a Canadian company. But to perform this contract, to perform the work under this contract, the EU company needs to send professionals to Canada. And this is where we can use this new exemption, this new work permit. So that's really interesting. Of course, you have a list of eligible profession. And also it's either an EU company contracting with a Canadian company, but it can also be a professional, like a professional contracting directly with a Canadian company, so going to perform the work. And there's a limited list of activities, but the list is really extended. And it's more, the only thing we're talking of a skilled position here, like engineers, technicians, but the accountants, but the list is really long. All IT people, they're also included in the list. Now, the well-known category of the intra-company transfers. Here, it's not a new work permit available to EU citizens, because the intra-company transfer is a category that we've been using a lot in the past. We have general provision specific to this category. What CETA has done is that CETA has facilitated this access to intra-company transfer. To be more specific, under the general provision, when you have a company, a foreign company, establishing a new company in Canada, the work permit that can be obtained is a 1-year work permit. So it's pretty unstable, because you're moving a family, so you're moving the main worker and his family. They're coming to Canada, and they are only granted a 1-year work permit. So it means that after 6 months, you'll already have to renew, to start the application for the renewal of this initial 1-year work permit. So it's unstable, because you never know if the renewal will be granted. Generally, it will be granted if you show good sign of economical activities in Canada, which is not always the case after only 6 months of activity. So CETA has brought the possibility to obtain a 3-year work permit initially. So you're a company established in the EU. You're creating a subsidiary in Canada, okay? You transferring key people to this newly established company in Canada. These key people will receive a 3-year work permit, even if your newly established company has been incorporated for a month. So that's really interesting. It changes the life of the applicants, of your candidate, and it brings more stability to your company. The rest of the terms and conditions to obtain, to be eligible to this intra companies transfer did not change really. So you can only transfer key people, either executives or specialists. Those people must have been hired by your company in Europe for at least 12 months, and then they can be transferred. Interesting to know with this program, you can always the EU company can continue to pay the candidate from Europe, so it can help when establishing a new business. So the Canadian company does not have to pay the salary of the EU citizen transfer. It can still be the parent company in the in Europe. Now, the business visitor status. It is very different from what we've seen, because here we're not talking of a new work permit or of the work permit or of any kind of work permit, because here it's a work permit exemption. So what is a work permit exemption? Is the possibility to come to Canada without a work permit, without the need for a work permit. You doesn't mean that you will be allowed to work, but you will be allowed to carry on a specific list of activities in Canada, like marketing research, training and seminars, trade fairs, things like that. What CETA has done is that it enables EU citizens to come up until 90 days in any 6-month period as business visitors, which is longer than under the general provision. And also the list of activities that can be conducted as business visitors has been increased. So that's also very interesting, because I mean, all companies, before deciding to really open new business, incorporate a subsidiary in a foreign country, in Canada, they really need to come to send people working on the market, analyze the market, and that can be done for a quite long period of 90 days without a work permit in Canada directly. So that's also very, very useful, and we use it a lot. Now, how to apply for a work permit under CETA. So I want to clarify something right away, is that CETA has not changed the rules to apply for a work permit. So it is the same rules that apply when you want to obtain a CETA work permit. It's the same rules that apply for all types of work permits. As an EU citizen, you will have 4 options when applying for a work permit. You can apply online. You can apply in person at a visa application center. This is something that we pretty much don't use anymore, so I won't be discussing this. You can request a preliminary opinion as well to a specific service of IRCC. It's kind of rare also. And as a European citizen, you can also apply for a work permit upon arrival to Canada. So you land in Canada, and at the airport, you can apply for your work permit directly. In my experience, we really use the online application and this application upon arrival. I would say maybe that would be 80%, 85% of all the application that we submit. That would be 15%, and here would be the rest. That would be 10%, and that would be the rest. Sorry. So applying online through MyCIC, what do we do? So always know that when applying for a work permit, there's 2 levels. You have the employer level. The employer must create a portal with the authority. It's called the employer portal. And the applicant must have his own portal as well. Of course, when hiring a legal firm, we will have those 2 portals active, and we would work on the 2 portals directly. The employer must submit what's called an electronic job offer, pay a fee of 230 Canadian dollars, and declare all the work conditions of the foreign worker he wants to hire. Then the candidate must give all details regarding all personal information for his application. So you have family information, you have also all information concerning his career, concerning the diplomas, concerning the background. Here you'll see how it goes. So the employer or its representative will fill out an electronic job offer and declare all the conditions of employment for the candidate he wants to hire. Then he will obtain a number. This number is given to the applicant, and here the applicant is applying online. Under 24 to 48 hours, the applicant will receive an invitation to submit biometrics. Then it's the processing time. The processing time is about 10 weeks generally. Depending on the position, you also have a right to a 2 week processing time, but I have to say that this is not really respected today, and even when you're eligible to a 2-week processing time, we have some delays, but generally 10 weeks is what you should expect to obtain a work permit when you apply online. Applying for a work permit upon arrival is something very different. So you've been given, we would give you a complete file of something I forgot to tell, okay? So when applying online, you will receive what's called a letter of introduction. This letter of introduction, you will receive it by email or in the portal. So and with this letter, when you arrive in Canada, you will give this letter to the immigration officer, and then your work permit will be issued. Here it's different. When applying to a work permit upon arrival, you don't have an approbation from the authority. So you have, when you arrive, to demonstrate that you're filling all the criteria to obtain a work permit in Canada. What's the main advantage of applying to a work permit upon arrival is the fact that there's no delay, there's no time processing. I mean, you fill an ETA application, you obtain your ETA application, you you take your flight, you arrive in Canada, and you say to the first immigration officer you meet that you want to be issued a work permit, that you need a work permit, that you're coming to work. So you're going to go to the immigration officer, the immigration services, and you'll meet with a specific immigration officer, and you will demonstrate that you have a right for a work permit. So there's some uncertainty in this process in applying upon arrival. So that's why we keep this option to specific application. We would not use it normally if you're traveling or if your employees are traveling with their families, because that could take a few hours before a meeting with an immigration officer. So we would recommend that the main applicant come first, obtain his work permit, and then the family can come. Of course, it is not available to all citizens in the world, only to visa exempted citizens, which is the case for EU citizens. And if we have an application where we're not 100% sure that all the criteria to obtain a work permit are met, we will normally recommend to apply online and not upon work permit or upon arrival. So there's an analysis to make here. Well, and that's it actually. I don't know if I went too fast, but I'm available if you have any other questions. If you want me to be more specific on one of the work permits we discussed.
Thank you, Natacha. This is Adrian again, and I think I was listening. I missed your one last year, and a lot of great information that you shared with us. Before we pass it over to Q&A, and I'll let Marie cover the Q&A, and there are some stuff in the chat, so she can read that with you, and we can discuss. So one, thank you for any of the people that have joined. these are the sort of, I'm just going to put a little plug in here. These are the sort of issues that we work with our members about. And so if there's anyone here that would like some follow-up, we can certainly connect you with Immetis to see if they can help your company. Or if you're interested in more of these topics and you're interested to potentially become a member of EU CAN, certainly reach out to me or Marie, and we can make those connections. So I wanted to put that little plug in here before we go on to the Q&A, and maybe I'll just use my position to kick off one question I have on the Q&A, which is actually the complete flip side of this. Do these provisions also, so I think for European companies operating in Canada, often we're looking to bring specialists and other people with sort of a unique understanding of our businesses into Canada to help support the Canadian teams. But the reverse is also of interest to us. So would these provisions also work bilaterally? So do these sort of similar positions for us to kind of send talent to Europe to either educate them or to learn more so they can come back to Canada? So that'll be my first question, if you can answer that, and then I'll let Marie take the rest.
Yes, it's bilateral. Yeah.
Excellent. Thank you. Marie, I hand it over to you to walk us through the Q&A.
Yeah, thank you very much, Adrian, and thank you so much, Natasha. I think definitely your presentation was so concrete and provides many very interesting information, very useful. We have already some questions, and I would like to ask the other attendees to not hesitate to ask their question in the Q&A box, because I will lead the moderation, and this way we will add the question to Natasha. We have, so Natasha, first question, I would say a bit more sectorial one asked and raised by Mario, and it's about the construction sector, because I think it's like a comment from Mario, and so the basis is like transfer qualified personnel from EU company to the Canadian subsidiary in Canada, so is limited to management positions from his understanding, but he underlies that from his observation in the construction sector, it's not really the reality, I would say, and just indicate that there is like a rate of 1 foreign per 5 locals people that can be applied. And so we would like to ask maybe, how do you see and observe the situation too, and how we can solve this to bring qualified labor without limitation on quantity?
Sorry, for the last part, to bring unqualified?
Qualified, sorry, to bring qualified labor without limitation on quantity.
Okay, we have options for people working in the construction first, but yes, it is true that CETA and provisions 10, CETA's Chapter 10 helps facilitate the entry for foreign workers, for skilled foreign workers, but it is not limited sector by sector. And when we're talking of transfers from EU to Canadian companies, it's not limited, it's limited to key people. So we're talking of executive management, but also to specialists. So a specialist is not necessarily a manager, but it's someone who has a specific knowledge of your company, of your industry, and this person can be transferred. So I think it kind of answer your question. So you're not limited to executive. Also, the key specialist can be transferred. And if the person you want to transfer are low wage positions, or they're unqualified, then you will have other options, but this won't be options under CETA.
Okay, thank you very much, Natasha. And please, George, Mario, let us know if you need more details regarding this answer. The second question is from George, and he asked a very concrete one. So, do we need an LMIA? And so, as I carefully listen to your presentation, I think it's Labor Mobility Impact Assessment. So, do we need a LMIA for an intra-company transfer?
No. This is the whole point. The basic rule to obtain a work permit is to follow the path of the LMIA. What is an LMIA? It's an authorization given to an employer to hire a foreign worker. But an LMIA is not necessarily under the for the CETA work permits. CETA work permits are LMIA exempted.
Okay, thank you very much, Natasha. And George has a second question, much more on the salary and the incomes. And so the question is about paying the salary of the transferee. How is it possible to comply with labor regulations? In comma, it means CPP, QPP, etc. And the question is, any worker in Canada would need to pay those things, right?
Well, I'm not sure I understand the question correctly, but I think that when we're talking of transferring, you don't have to follow the median salary in Canada. So you can keep the salary, you're free on the salary you're offering to your transferee candidate.
Okay, I think,
but to a limit, of course, because otherwise it's not with immigration, it's not a breach of immigration rules, but you wouldn't be allowed to hire people under the minimum wage in Canada, of course. But and it's very different when you're following the path of an LMIA where you really have binding rules regarding the salary. When we're talking of intra-company transfer, you're more free on the salary that you have to offer. You don't have to follow the medium salary per position.
Okay, thank you very much, Natasha. And please, George, let us know if you need, you want to give more details or something more specific.
And also, just to finish on that, the person can always remain paid by the company in Europe and doesn't need to be paid in Canada.
Okay, great. We've got another concrete question from someone asking if there any solution available for a company from the European Union to send an employee to Canada to provide a service without having to apply for work permits. And it indicates that it is for a short period of time.
Okay, could you specify what short period of time? Because there's one possibility, but it's a very limited possibility. So if the short period of time is less than 30 days, it is possible. Then you'll apply for an exemption of work permit. So less than 30 days for per 1 year period, it's possible, or less than 15 days per 6 months period. But if it's over 30 days or over 15 days, it is not possible. You really need a work permit, and it's for skilled positions.
Okay, great. Thank you very much, Natasha.
And it has nothing. It has nothing to do with CETA. This is other kind of provision.
Okay. Okay, good to know. Maybe a specific question. Yeah, I think it's quite interesting too, and you mentioned it, but I think it's about the internships and trainees. So we have a question. Do you know if unpaid interns, in comma, less than 6 months internship? So do you know if unpaid interns can apply for permits at the airport upon arrival in Canada? Yeah, so this is not really about.
Well, you have another path which is called stage co-op, available for a specific citizen. So I know it's available for French people, and here under this path, the stage can be unpaid. So, and you declare it in the employer portal that you have a candidate applying for what is called a stage co-op, and that is not going to be paid. So this is possible under this path. You also have the possibility to have through CETA, and it's a new possibility. Actually, it's a possibility that I didn't discuss during the presentation, but you have this possibility to have interns transfer to Canada under the intra-company transferring path. However, I don't know if that could be used in your situation, because these interns must have been hired by your company for over a year before they can be transferred. So normally it's not interns like we have in mind. It's more people like gaining in your company in Europe, gaining experience in another country. So that's kind of different. So I would recommend that for unpaid internships, that you follow the path of stage co-op, but it's more limited on the citizenship, on the citizens who can benefit from it.
Okay, thank you very much, Natasha. Maybe to come back to the question regarding the salaries and the income, we've got an additional questions, which is quite concrete and precise. Regarding payment of salaries, you mentioned that salary can be paid in Europe.
Mm-hmm.
How is that impacting on CPP EI contributions and access to OHIP, which is the health system in Ontario, for example?
That I don't know. This is not something I'm doing. I'm not a specialist of this of the social coverage system. I'm sorry.
Yes, on this one, maybe I would recommend to go much more regarding Finance Ontario and this kind of services. Will be more stable, I think so. But just in case, Natasha, it was just to ask you, but I agree with you. So Mario, please, we can help also in connecting with Ontario services or some connection we have with financial services there in provinces. We have many questions, and we are very happy, and thank you all again for attending today. So we've got a question still on LMIA. So the question is, I understand there are significant advantages for European companies operating in Canada and investors. So that's what you mentioned, Natasha, during your presentation.
In Canada and where?
I understand there are significant advantages for European companies operating in Canada and investors. The investors.
Ah, oui, yes.
Yeah. Are there aspects that make it easier to receive an NLMIA for European citizen for a company in Canada that does not have operations in Europe? Because it's a company which only import from Europe.
Okay, it's a long question. Could you send it to me? Can I read it? I got access to it.
You got it? Yes, it's a question for Balin Nagy, and the time is 10:40.
Okay. Other aspects that make it easier to receive an LMIA for a European. Okay, Nagy, I'm reading your question. I'm not sure and I understand it correctly. Are there aspects that make it easier to receive an LMIA for a European citizen for a company in Canada that does not have? No, not really. I mean, You mean that the Canadian company here isn't, so cannot benefit from CETA provisions, so the company will have to follow the path of an LMIA, but there's no, it's not a question of making it easier or harder, it's really the question of following the criteria for an LMIA. And bottom line, what you have to look through when applying for an LMIA is that your company has sufficient funds to pay the foreign workers, that the salary offered to the foreign worker is compliant with the Canadian minimum per profession and per experience, and that your worker has sufficient experience for the job is for the job offer he received. That's pretty much the thing to look at.
Okay, thank you very much, Natasha. We go to the next one. So a question from Alphonse Calderon. Can a EU parent company easily transfer flow plant employees to its branch in Canada? Can they be considered as specialists?
Actually, I've seen that a few times. It's not the easiest file to prepare. I've seen that for instance, for people working in logistics, because they were very seasoned, very skilled with the specific logistics system of the company. So I've seen that. I've seen that a few times. It's possible. It's not easy, but we're not limited in the job category. So you know, flow. So it's. I would say that it really depends on what floor plant employees, what your floor plant employees are doing. And they really need to have specific knowledge of one of the system of the company.
Okay, great. Thank you very much, Natasha. As we just have a few minutes left, I would like also to give the opportunity to other people to ask questions, because I see we see Georges and Mario, the other an additional question. If you agree, we can also have some emails as a follow-up after the webinar. Oh. Because I think they cover again this question about salaries, incomes, and as we mentioned, we are not so on this kind and focused today. We are much more on CETA and labor mobility provisions, and I think on this scope we're a bit more on the financial side. So another question is asked by Melina Young, and the question is: can an EU citizen contractual service supplier or independent professional applying under T43 or T47 be paid by an EU-based company, or can only be paid by Canadian company? Again, about the income. If you're on the sidebar, it's a bit,
yeah,
yes.
No, but Melina, the question here is the company was going to get paid, not the employee. So you have this EU service supplier, okay, who's applying to come perform some work from the Canadian company. So the Canadian company will pay for the contract. So we'll pay the EU company for the contract. And then the EU company will pay the person, its employee, who performed the work. So and if we're talking of a professional performing a work directly for a Canadian company, there the professional will be paid directly by the Canadian company. So here, the question of payment depends on the term of the contract. What's not possible is that the person coming under these specific exemptions become an employee of the Canadian company. But the rest can be clarified within the terms of the contract underlying this possibility for a work permit.
Okay, thank you very much, Natacha. Maybe a last question, or
yes?
If there is still one, and we've got, and I think then it will be time to conclude. This one is from Margarita Vega, and the question is, what is considered what is considered a qualified worker for the purposes of intra-company transfer, and how can we prove this qualification?
Well, for the intra-company transfers, it's not a question of qualified worker. It's really the question of executive or specialist. Executive, well, it's pretty obvious. It's an easier proof to do. For a specialist, it's someone who has a specific knowledge of your company, of your industry, of your system, your hardware, your software. So it is really a skill that you couldn't find in Canada because it's unavailable. It's only available for people who've been working in your company. So this is actually, it is a proof that you have to make, and it's a difficult one. So what we do generally, we will show that, for instance, you have systems, you have IT systems that been adapted, and that the person's been working and know this system, but it really has to be something that it's that is owned, a knowledge that is owned by your company. That's really the criteria. It's not the question of qualified or unqualified. It's the question of knowledge owned by your company, and that people that you're transferring have this specific knowledge of your company.
Okay, perfect. Thank you very much, Natacha. I think we are just right in time, and we can conclude the webinar. Do you want to have some final words before I just end and thank you?
No, thank you very much for organizing this. You know, the provision under CETA that helps the entry for foreign workers are very unknown. They're fully used, and so I'm really happy to share these options for EU companies and EU citizens with you. Thank you very much for your invitation, Marie.
Right. No, thank you, Natacha, and thank you, everyone, and all the attendees today. You were quite a lot and numerous, and we are very, very happy and delighted to get this webinar. And we can see that definitely it's a very interesting topic for many companies that attend this too. We would like to thank you again, so Natacha and all the attendees. As you know, also for the next steps, so this was a webinar today because the aim is for EUCAN to provide the information to support also the trade and business relation between the EU and Canada. We have also a role and a work on advocacy, so I just call all the attendees and companies which are and who are interested in continuing working on this topic to contact us. We would be very pleased to continue working together on those questions and to potentially coordinate some recommendation or position we could voice just to get and to continue getting smooth labor mobility between the EU and Canada through the CETA. And thank you again. So thank you all. Have a very great day and looking forward to seeing you soon. Thank you, Natacha. See you soon.
Thank you very much. Thank you very much.
Thank you. Bye.